John is doing this. Let me go ahead and testify on John's behalf. This is John in Texas, and when I had a little encounter with the three-letter agency FBI, and they took property from me. Well, actually, it wasn't the FBI, but they were aware of it. It was a local county sheriff, and they took it without a warrant. I was kind of scratching my head, and I was talking to John about it. And John happens to be one of our resident experts on a subject matter that very few people know what he knows about on the search and seizure laws. And I'm just going to testify to that and say that I don't have the qualifications to say what I just said because I don't really know what most people know. But I'm just doing it as a let me have my poetic license to give this testimony about John's abilities. In my opinion, I believe he knows more about the subject than many lawyers that I've spoken to. And in a heartbeat, I was able to get my property back in 3 days by following John's very succinct instructions about a post-seizure hearing. And when I threatened that post-seizure hearing, because I had a seizure without and they didn't do the forfeiture, and they didn't properly give me a post-seizure hearing, they took property without just compensation. And within 3 days of me sending off that notice of my request and requirement for a post-seizure hearing about property, I had the FBI agents handing me my property back, which was a backpack full of computers and paperwork, etc. Now, granted, they had gone through and disheveled everything, and it was all scoopy odd and different and odd and whatever. But I did get every piece of my property back, every last piece of it, within 72 hours. John, I don't have. John, are you up and ready? It's 9 o'clock, top of the hour. We're going to try to do this without sharing the screen because when John looks at his participants, he only sees about 140. I got 178. So there's some kind of glitch in the system where he's not sharing the screen with only half the crowd or 2/3 of the crowd or something like that. So it will not be on the recording.
Oh, my. Okay. Yeah. All right. Thank you.
Okay. So go ahead, John. You are, by the way, guys, this is John. Ladies and gentlemen, this is John in Texas. He's been on a few of other House of Prayer calls, and he's kind of branched out and gone in some of the other calls recently on We Are the Law. And he's what we call our wise elder in the room. So, John?
Well, due to technical difficulties, we will not have a lot of screen sharing. So basically what I want to talk about tonight is something that a lot of people wind up having trouble with, but nobody really knows what to do, including the lawyers. Generally, when you go to a lawyer and you tell him that the IRS seized your bank account, their response is, "Oh, bad luck." Well, the reason that's like that, and the reason that you hear about all these seizures in the states where somebody's going along and they get their life seized from them by some cop that stopped them for no good reason, and they found out they just happened to have some cash on them and all that stuff. The reason that happens is the lawyers don't know what to do. There's one set of lawyers in the United States that know how to handle a seizure, but they don't realize that their expertise works on all seizures and not just boats. So what I'm going to do is I'm going to run through a few of the statutes and stuff that kind of give you a hint on how to handle a seizure and the rules, and I'll point you in a direction. I wish we could show a few of these things, but in 25 minutes we can't get into a whole lot. So what people have to understand when they're dealing with seizures is the difference between a seizure and a forfeiture. It's two different things. Just because the government takes it does not mean that they have title to it. What they're doing is they're just holding it. And let's see here. There is, I'll get to it in a minute, but there's a case that says that when the IRS seizes something, the agent holds it in his administrative capacity. It doesn't change hands. He's just holding on to it. So 7401 is where we'll start. No civil action for the collection or recovery of taxes or of any fine, penalty, or forfeiture shall be commenced unless the Secretary authorizes or sanctions the proceedings, and the Attorney General or his delegate directs that the action be commenced. Now that takes a piece of paper. And when they try to forfeit something, they are supposed to file an action. If the IRS seizes something, or anybody else, any other government agent seizes something, then you have certain things that you can do to speed things up. And one of those things is you have to make a claim. And the way I like to explain it is, if you're a 4-year-old kid and you're playing on the playground and some other little a-hole comes along and gets your truck, the first thing you're going to do is stand up and say, "That's mine, give it back." Well, that's exactly what you have to do in a seizure. You have to make a claim. The claim has to say certain things, and it has to be in a certain way. And when you do that, all of a sudden, the burden shifts. It shifts from the little stupid affidavit that the cop gives, where he says he thinks that the seizure might be drug money, or he thinks that this car was hauling drugs or something like that. They always put in an affidavit. And until that affidavit is controverted, their BS stands. And you have to convert the affidavit or controvert the affidavit. And the way you controvert it is with a verified claim, because you're going to swear under penalty of perjury. You're going to claim all rights, title, and interest to whatever they stole. And you're going to claim that it's not derived from a crime. And the burden then shifts to them. It's called the relation back doctrine. It's going to shift to them that they have to prove it. And when they don't prove it and can't prove it and can't bring any evidence, then you get your stuff back. Now, the arrest of property is the same as arrest of a person. If you make a claim, they have to get you in front of a judge within 3 days, just like a person. I have recovered seizures from the Internal Revenue Service in 3 days. And they did just exactly what they were supposed to do. But I did just exactly like the law required and recovered the stuff just about immediately. Now, let's go to 7403. Now, 7403, 26 U.S.C. 7403, action to enforce a lien or subject property to payment of a tax. Now, listen to this second word. In any case where there's been a refusal or neglect to pay any tax or to discharge any liability in respect thereof, whether or not levy has been made, the Attorney General or his delegate, at the request of the Secretary, may direct a civil action to be filed in a district court of the United States to enforce the lien of the United States under this title with respect to such tax liability, or to subject any property of the delinquent, blah, blah, blah. They're going to try to take everything you got. So you have to realize the words: any case, any tax, any liability. Any is a real big word. So any time that they take something from you, you're entitled to your due process. And that's all laid out in the rules and the law and all that kind of stuff, that you get your due process. The only issue is nobody knows how to get to it. There's certain things you have to do. And when they can't come back and show that you violated the law or the property was used illegally, they don't have legs to stand on. Now, 7323, let me run over here and find that right quick. There it is. Judicial action to enforce a forfeiture. Now, if you don't think that we're not dealing with some maritime stuff, listen to this statute. Judicial action to enforce a forfeiture. The proceedings to enforce a forfeiture shall be in the nature of a proceeding in rem in the United States District Court for the district where such seizure is made. It's an in rem procedure. And any of you boys know that in rem stuff is against the thing, and it's purely an admiralty action. So When you get there, then you have to go down to the supplemental rules. Crap, I just closed what I wanted there. All right, here we go. Supplemental rules. Let's go to Rule A. This is the supplemental rules of admiralty. You find it right behind the civil rules, the federal civil rules, right behind it. There's a section, and it's rules A through G. And these rules, this is the scope of the rules. These supplemental rules apply to the procedures in admiralty and maritime claims within the meaning of Rule 9H with respect to the following remedies: maritime attachment and garnishment, actions in rem, possessory and partition actions, and actions for exoneration from limitation and liability. Forfeiture actions in rem arising from a federal statute. So any federal statute where they're trying to take something from somebody goes on these rules are the ones they have to go by. Now, this is a good thing to remember. The federal rules of civil procedures also apply to the foregoing proceedings except to the extent that they are inconsistent with these supplemental rules. These supplemental rules are superior to the civil rules. So when there's a couple of things we're going to hit right here in just a minute, and when you see it, the government gets a little bit of meat in the seat on this deal because there's certain requirements that they have to follow. They never do. And when they don't do them, you can have their paperwork thrown out. Let's see here. I'm going to go up to, custom law. Let's see, 7327. So if you want to know where the laws are, what body of law is governing all the seizures, you can look at 26 U.S.C. 7327. Custom laws applicable. The provisions of law applicable to the remission or mitigation by the Secretary of Forfeitures under the custom laws shall apply to forfeitures incurred or alleged to have been incurred under the Internal Revenue laws. So they take all the Title 26 and they enforce it with customs laws and the supplemental rules. So that's where your relief is in all those laws. So let's see when we're rocking along. All right, Rule A. Now, these rules A through G, there's a couple of them that don't really apply here, but Rule C is responsive pleadings and interrogatories. So you have to make a claim. Let me see. This is the second Rule C. Let me find the other Rule C. Verification. Okay. In rem action special provisions. When applicable, an action in rem may be brought to enforce any maritime lien, or whenever a statute of the United States provides for a maritime action in rem or a proceeding analogous thereto. That's where they hide 90% of these actions in court, is a proceeding analogous thereto. So they give it the duck test. If it looks like a duck, quacks like a duck, walks like a duck, it's a duck. So it's the same thing with these maritime actions. So it says, except as otherwise provided by law, a party may proceed in rem, may also, in the attorney, proceed in personam against any person who may be liable. Statutory provisions exempting vessels or other property owned or possessed by or operated by or for the United States from arrest or seizure, we don't need to know about that. But now the complaint. If the government particularly writes an action against you, the complaint, in an action in rem, the complaint must be verified. Somebody has to swear on the dotted line to everything that's in that complaint. They have to describe with reasonable particularity the property that's subject to the action and state that the property is within the district or will be within the district while the action is pending. So that's the big thing. They never verify a complaint. It's just against their Constitution to swear to anything. Now, the other interesting thing in Rule C is statement of interest in an action in rem. Now, the statement of interest is what I call a claim. Okay? Your interest, you're claiming your interest when you do this thing. It says the statement of right or interest must describe the interest in the property that supports the person's demand for its restitution or right to defend the action. Let's see, an agent, bailee, or attorney must state the authority to file a statement of right or interest on the behalf of another. And when you make a claim, if there's a lawyer handling it, he has to make that statement. He has to say that he has the authority. A person who asserts a right of possession or any ownership interest must serve an answer within 21 days after filing the statement of interest or right. So there's procedures in this stuff that hardly anybody knows about. But the CDE, okay, let's go to Rule E.
Hey, John.
Yes.
I was just going to ask you real quick. I got a situation. I've been itching to listen to you talk. Oh, brother. Oh, Lordy B. He can rattle it off like nobody business.
Well, let me get through this and then
just real quick. How much success do you think somebody might have if they had something taken away, such as a couple of so-called firearms many years ago? The firearms did not get destroyed; they got sold allegedly to somebody in law enforcement, so they're still out there.
Did you ever get a forfeiture notice?
Not that I know of.
Okay, here's the deal. If the government seizes something and forfeits it, and you don't get a notice of that forfeiture, your claim is alive and well. And what happens is if they don't have the property or can't get the property, you can convert it to a Bivens action and sue the one that made the mistake.
Lordy, because we might need to talk later because there is somebody that I specifically know. They didn't make a mistake. They did it on purpose. And I was just wondering how on earth I could get to them. And you just told me how. Thank you, brother.
Well, you can also get interest and all that stuff. I'll get to it in just a minute.
Okay, thank you.
Rule E, actions in rem and quasi-in rem general provisions. So, except as otherwise provided, the rule applies to actions in personam with process of maritime attachment, garnishment, actions in rem, and possessory and petition actions supplementing rules B, C, and D. Complaint. Okay, they're going to make the plaint. Security. In the actions to which this rule is applicable, the complaint shall state the circumstances from which the claim arises and with particularity that the defendant or claimant will be able, without moving for a more definite statement, to commence an investigation of the facts and to frame a responsive pleading. Now, this is the good part. Subject to the provisions of Rule 54D and of relevant statutes, the court may, on the filing of the complaint or on the appearance of the defendant, claimant, or any other party, or at any later time, require the plaintiff, defendant, claimant, or any other party to give security or additional security in such sum as the court will direct to pay all costs and expenses and will be awarded against the party by any interlocutory order or final judgment or an appeal to any appellate court. So any claimant that comes after you, you can go in at your when you have your post-seizure hearing, you can go in and say, Your Honor, he needs to bond his action. He's going to have to bond because if I win, he's going to lose. He's got to protect me. And there's the rule, Rule E, right there, E, B. That's the judge's authority to make the whatever agency's coming at you bond their action. Okay, now let's see. Let's go to E. We'll run down to Rule G. Okay. This is Rule G, and Rule G is a new rule that's gone in, and they changed it a few years ago when they added the new forfeiture laws that everybody's running around under. The rule governs a forfeiture action in rem arising from a federal statute, and that means any federal statute, to the extent that this rule does not address an issue. Supplemental Rules C and E and the Federal Rules of Civil Procedure also apply. The complaint must be verified. State the grounds for subject matter jurisdiction, in rem jurisdiction over the defendant property, and venue. Describe the property with reasonable particularity, and if the property is tangible, state its location when any seizure occurred, and if different, its location when the action is filed. Identify the statute under which the forfeiture action is brought, and state sufficiently detailed facts to support a reasonable belief that the government will be able to meet its burden of proof at trial. So, once again, they have to verify their complaint. These guys will not verify the complaint. If they don't verify their complaint, you can have their complaint stricken for failure to live up to the rules. I've got some other cases that say they have to live up to the letter of the law if they're going to forfeit. Let's see. The other rule, or other part of Rule G that's interesting is filing a claim. The claim must be signed by the claimant under penalty of perjury. That's why we call it a verified claim. And be served on the government attorney designated under Rule G4A, blah, blah, blah. Unless the court for good cause sets a different time, the claim must be filed by the time stated in the direct notice sent under Rule G4. So what happens is when they see stuff, they're going to do it right. They're going to send you all these notices and tell you how long you've got to reply and all that kind of stuff if you make a claim on the property. But in the case of the IRS, they don't ever do that. They just take the money and you never hear from them again. They'll take your bank account and all that stuff, and if you don't do anything or say anything, they don't either. So it's my position, and I've yet to go in and dial anybody up on this, but if you had a seizure by the IRS and they never sent you a forfeiture hearing, and I've got cases to support what I'm saying here, if you never receive a forfeiture notice, no clock starts ticking on you. So you could go back and file a claim for that property, and if you waited long enough, the Internal Revenue Service would be stopped from trying to come back and make a claim because their lien is only for 10 years, and in some cases, Title 28 says the United States only has 5 years to file something. So depending on which statute they wind up going with, after a certain amount of time, the IRS couldn't even come back and try to sue you for it. So there they'd be, 11 years down the road, and you come in and you get the money back plus all the interest. And let me see here, $28,465. Here is a little bonus, and if the lawyers of the world knew this, there would be, they'd get this whipped right out. 28 U.S.C. 2465, return of property to claimant, liability for wrongful seizure, attorney fees, cost, and interest. Upon the entry of a judgment for the claimant in a proceeding to condemn or forfeit property seized or arrested under the provision of federal law, except as provided in paragraph 2, any civil proceeding to forfeit property under any provision of federal law in which the claimant substantially prevails, the United States shall be liable for A, reasonable attorney fees and other litigation costs reasonably incurred by the claimant, post-judgment interest set forth, and it's the interest that the government pays, in cases involving currency and other negotiable instruments of the proceeds of an interlocutory sale, interest actually paid, blah, blah, blah. So you win on one of those things, they got to pay your attorney's fees. They got to pay you interest on any money you get back. Those boys are hosed. People don't know that. Okay. How much time I got, Daniel?
You got 5 minutes left. Well, a little bit over 5 minutes. That's a good call.
Okay. We're going to talk just a minute about presumptions. Okay. Presumptions are used every single day in our system. And what a lot of these guys talk about when they say they go in and give the court, they say, well, I don't have this contract and I don't have that contract and all that kind of stuff. And they think the system is built around contracts. That's not exactly it. The system is built around presumptions. And when you go in there and you tell them, say, oh, I don't have this contract, I don't have that contract, and you know how to deal with it, all of a sudden you take the judge's ability to use those presumptions against you, and now then all of a sudden he can't do it. And when he can't do it, they can't run the scheme against you. I've done this about a jillion times on presumptions, and they really there's problems with using presumptions against you because it's unconstitutional. Let me open this file up right quick and I'll read you a little bit. Okay. Here's one of my favorite ones. Presumptions which prejudice constitutionality guaranteed rights are unconstitutional and may not be employed. Vlandis v. Klein, 412 U.S. 441. That's a Supreme Court case. So here's the deal. Anybody that's ever had a traffic ticket in an automobile or a pickup or anything like that, the government used the presumption against you that you were involved in commerce. And if you'll look at the definition of motor vehicle at Title 28, Section 31, Number 6, it's going to tell you that a motor vehicle is used for commercial purposes. Well, if you're going to get groceries at the grocery store, you're not involved in any commerce. The burden of proof is on the government to prove that you were. It's an element of the charge. And if you don't know about it, they describe your automobile in their ticket as a motor vehicle or a vehicle. The judge makes the presumption that you were in commerce and the law applies to you. Well, you go in there and break that presumption and you say, well, here's the thing. The cops are enforcing a privilege to drive and I'm driving under the right to drive. I'm the right to travel. And you ask, what's the difference between a privilege and a right? And I'm going to tell you. A privilege is using the roads to make money, and it's regulatable by the state. But the right to drive is everybody's, and you can use any road you want, and they can't regulate it. They can't charge you for a license. They can't charge you for squat because it's a right. So anyway, beware of presumptions. I've got a bunch of good cases and how they apply and all that kind of stuff. So I said all I could say in 30 minutes. I shut up.
John, you did really good. And because of the glitch and whatever happened in our computers, I show 193 participants right now, and I'm sure you don't show that. So that's probably the reason why something's wrong.
For some reason I do. I show 194 now.
Oh, you probably could share your screen right now, lo and behold. But nonetheless, I think we did a good job. I don't think you could have probably done as good with the sharing the screen. We probably would have had a lot less substance. So just to let everybody know, there's more than one way to do things. Different people have their opinions about the way they do things. I do appreciate what John has shared because I personally have used his process of seizure, not search and seizure, but of seizure, post-seizure hearings. And later on this year, we've been talking about putting together a specialized class for interested parties. If that's something that you would like to participate in, please direct message me right here. I'm the moderator, Daniel Joseph, or you can use my iamdanieljoseph at protonmail.com. And we will be putting together a class and helping people retrieve their property. It's a doable process. I don't know. There might be more than one way to do this. I've noticed a lot of people talking on the chat, chitter-chatter back and forth, and everybody wants to tell everybody how their process is better and so-and-so's is worse. How about let's just say it's different. You do it differently. What's better is when you get the boot off your neck and when you get your stuff back. So that's better. You think you have a better way, then I think that's what you should do for you. I support what John did because it worked for me, and you weren't there at the time when he was helping me, and I do appreciate what you share, John. And I know that behind what you're saying, we visit regularly is substance, and it's not a bunch of fluff, and we have a lot of people that we've helped besides. So thank you for sharing. Anything else that you want to say? But you got 1 minute left.
Oh, well, I tell you, there's a lot of smart people on here. A lot of them a lot smarter than me, but I'm glad that we have the opportunity to get together like this, and we can keep getting together like this. And I think when we work together and we share our results, I think it's better for everybody. We can decide which process works by the results we get, and how complex or simple they are. And I think it's something that we need to do because our government is some screwed up.
Okay, John, thank you so much. You said our government. You must have had a mouse in your pocket.
Yeah, right.
I gotta mention something too. I got $50,000 back on IRS for one guy, a few years ago, and they didn't like the process that I gave them. But anything where you get something back is always good,
I appreciate that.